At the break of dawn, exactly 12 hours after the legal foundations of the executive branch were shaken by unprecedented testimony, federal law enforcement began a coordinated operation across multiple states to secure assets valued at over $1 billion. This escalation followed a Saturday session where Melania Trump testified under oath before all 9 justices of the Supreme Court, providing documentation that prompted an emergency order within just 4 hours of her departure. The scene was one of clinical efficiency as U.S. Marshals arrived at Mar-a-Lago at 6:12 a.m., followed by entries into Trump Tower and the Bedminster property shortly thereafter. These actions were not merely symbolic. They represented the physical manifestation of a massive judicial freeze covering 17 properties and 347 bank accounts across 6 different jurisdictions. The former First Lady's decision to bypass spousal privilege and provide internal communications and financial records spanning 8 years has created a legal vacuum that the current House leadership is now struggling to fill. The political atmosphere in Washington has reached a fever pitch as the House of Representatives prepares for an emergency oversight hearing, leaving many to wonder if the leadership can maintain any semblance of order over the chamber. Before we go to deep analysis, please take a moment to subscribe to the channel so you never miss an update on these rapidly evolving events. The House Oversight Committee's decision to convene on Tuesday, February 10th, signals a desperate attempt to address executive asset management as the judiciary moves at a speed never before seen in American history. This shift in power highlights the central problem. Can the legislative branch exert control when the judicial branch has already initiated same-day seizure orders based on live, incriminating testimony? The core of the crisis lies in the 214 pages of transcript generated during Melania Trump's nearly 12-hour session at the Supreme Court. She didn't just answer questions, she provided what experts call textbook cooperation, including bank confirmations and handwritten notes that directly contradicted previous legal defenses. The most damaging evidence involved 17 wire transfers totaling $847 million sent to entities in Cyprus, Switzerland, and the Cayman Islands. These transfers occurred between March 2025 and January 2026, a period during which federal freeze orders were already supposed to have halted all movement of funds. When asked why she signed these authorizations, the former First Lady testified that she was told they were routine business matters and was unaware they were subject to a judicial order. This testimony effectively shifted the legal crosshairs from the family itself to the legal team that advised them, creating a rift that has left House allies in a state of strategic paralysis. A significant question emerging from these events is how such a massive volume of capital could be moved despite active court orders. The answer is found in Exhibit K, a document Melania Trump submitted voluntarily even as her own legal team attempted to block its introduction. This exhibit contained timestamped bank confirmations showing that $340 million moved through a Nevada LLC as late as January 2026. This revelation directly led to the criminal referral of 3 attorneys who advised on these transfers. By Friday morning, federal authorities had intercepted 2 of these lawyers at Teterboro Airport as they attempted to leave the country, while the third surrendered voluntarily. This rapid sequence of arrests has sent shockwaves through the House, as the individuals responsible for legal strategy are now facing obstruction charges, leaving the political defense of the former president without its primary architects. The terror felt within the halls of Congress stems from the loss of the narrative, as the House Oversight Committee finds itself reacting to facts on the ground rather than setting the agenda. Why is the House losing control? It is because the Supreme Court's use of emergency jurisdiction has bypassed the usual months of appeals and delays that political leaders rely on to manage public perception. For the first time in 230 years, the court issued same-day seizure orders following live testimony, a move that suggests the justices believed any delay would result in further asset flight. This judicial assertiveness has left MAGA Mike and his colleagues with few options, as they are forced to hold hearings on asset management after the assets have already been seized by federal marshals. The institutional weight of the federal government is moving faster than the legislative process can accommodate, creating a sense of panic among those who promised to protect the former administration from such scrutiny. The evidence provided by the former First Lady included personal, handwritten notes from December 14th that documented conversations with her husband regarding the transfers. Although partially redacted, the visible portions show she was told not to worry and that the court orders did not apply to their specific situation. This contemporaneous documentation is devastating because it provides a window into the intent behind the financial maneuvers. It answers the question of whether the violations were accidental or a deliberate challenge to judicial authority. While Trump loyalists like Senator Mike Lee argue that this is the criminalization of marriage and a violation of spousal privilege, constitutional experts note that the privilege was waived voluntarily by the witness herself. This legal reality makes it nearly impossible for House leadership to claim the process is purely a political persecution, when the primary witness is a member of the inner circle who chose to cooperate to avoid her own criminal exposure. As the investigation expands, the focus has shifted to other family members who held signatory authority on the flagged accounts, including Donald Jr. and Eric Trump. While subpoenas for them have not yet been confirmed, the legal trail established by Melania's 14 offshore accounts has provided a roadmap for the special counsel's office. This creates a massive problem for the House majority, which now faces the prospect of a cascading series of indictments involving the entire executive apparatus. The strategy of the prosecution is clear: build a ladder by charging the advisors first and using their potential cooperation to reach higher levels of the organization. This Enron-style playbook is being executed with military precision, leaving House leaders to scramble for a response as their traditional allies in the legal profession are placed in federal custody. The real-world implications of these seizures are already being felt beyond the headlines, affecting hundreds of regular employees and the broader economy. Mar-a-Lago and the Bedminster property alone employ over 800 people whose jobs are now in a state of total uncertainty due to the freeze orders. Furthermore, financial markets reacted sharply to the news, with futures dropping 2–3% as investors process the instability of the situation. This economic volatility places additional pressure on House leadership to project stability. Yet the internal contradictions within the legal defense make this impossible. While the former president's team issued a statement claiming the testimony was coerced and unreliable, this was immediately undermined by court filings showing the voluntary nature of the document submissions. This public break between the legal teams of the former president and the former first lady has created a chaotic environment where no one is sure who is truly in charge of the defense strategy. Looking ahead, the calendar is marked by critical deadlines that will determine the finality of these asset seizures. Monday, February 9th, will see the arraignment of the 3 arrested attorneys, where the specific details of the obstruction charges will be made public. Following the House oversight hearing on Tuesday, the Supreme Court will reconvene on Thursday, February 12th, to decide if the seizure orders should become permanent pending a full trial. If the justices uphold the orders, the process of permanent forfeiture will begin immediately, representing a total loss of control over the $1.2 billion in domestic and international assets. The speed of these developments is the primary cause of the current political terror, as every day brings new filings that the House leadership is unable to block or even effectively delay. In conclusion, the situation facing the House leadership is one of unprecedented complexity and rapid decline. The combination of voluntary testimony from the highest level of the former executive branch, the immediate seizure of $1 billion asset portfolio, and the criminal prosecution of top legal advisors has left the political establishment in a state of shock. The House is losing control because the traditional methods of political defense are being bypassed by a judiciary that is prioritizing the integrity of its orders over political convenience. As we move toward the critical court dates this week, the full extent of the legal and political fallout will continue to emerge. Thank you for watching this in-depth analysis of the documents and data shaping our current reality. If you found this information helpful and want to stay informed more, please subscribe to the channel, like this video, and share your thoughts in the comments below. Thank you for watching.